Good evening, friends. We had done one session between the interplay of Section 17 and 49 of the Registration Act. But today's session would be short, but crisp once we have Justice A. Hari Prasad, a former judge of Kerala High Court and a senior advocate practicing in Supreme Court of India, as well as the other high courts. As we all know that a judge can practice in all other high courts except where he was made permanent. Section 49 of the Registration Act in respect of the non-registration of the compulsorily registrable documents is a topic that is niche but quite interesting, not only for the persons associated with law, but also beyond that. We are too happy that Justice Hari Prasad has agreed for the session. I keep on bothering him in the morning session when we exchange the pleasantries that, sir, we should have a session because we keep on receiving requests. Today only I had shared one of his sessions has already touched 15,000 views. Over to you, sir, and thank you for accepting our invite.
And thank you, my friend, because I am slightly apologetic because I could not do it on an early occasion because I had promised him to do that. Anyway, I'm happy that we are joining again for another session on an important topic, probably as Mr. Vikas said, that is not only important for the lawyer fraternity, but also for the those who handle this land transactions. Everyone is likely to be affected by the principles in Section 49. So, to understand the principles in Section 49, I'll just make a passing mention of Section 17 and 18, which Mr. Vikas was telling that there was a full-fledged session on that. But then, anyway, as an introductory thing, I'll have to go to part 3 of Registration Act, which deals with this compulsory registrable documents and the optionally registrable documents. That is sections 17 and 18. Now, before that, I'll just take you to the history of Registration Act. Registration Act is of the year 1908, the same year in which CPC was enacted. Similarly, the original Limitation Act, which was replaced in 1963, the original Limitation Act was also enacted in 1908. So, major land laws were conceived, drafted, and then it was enforced in 1908, which is a landmark year for this type of transactions. So, with that note, I'll go to Section 17 first. I may not dwell much time on Section 17. I'll just explain and just make a passing mention of it. Section 17 deals with documents which registration is compulsory. Now, the section itself is very clear, not very complicated. Instruments of gift of immobile property. So that, irrespective of the value, a gift is a compulsorily registrable document, even if it is below 100 rupees. Because even in TP Act, Section 122, 123, you will find the mention that a gift is a compulsorily registrable document. Then 17(1)(b) says, other non-testamentary instruments which instruments which purport operate to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or interest, whether vested or contingent, of the value of 100 rupees and upwards, to or in immobile property. So anything, any effect caused by a document on immobile property, whether it is whether it is to create, declare, assign, limit or extinguish, and that too whether in present or in future, any right, title or interest, whether vested or contingent, of value of 100 upwards. So any transaction normally in the present day, you cannot have a property, immobile property less than 100 rupees. So all transactions are covered by Section 17(1)(b), which is compulsorily registrable. Then other documents, I'm not going to the other part of the section because other non-testamentary instruments which acknowledge the receipt of payment of any consideration on account of the creation, declaration, assignment, limitation or extinction of any such right, title or interest, it goes on like lease of immobile property from year to year. So many types of documents have been mentioned in Section 17 which are compulsorily registrable. What is the effect of non-registration of such documents is the question. That is directly answered in Section 49. And before that, I'll just make a mention of section 18 also, which says that there are certain documents which are optionally registrable. For example, I'll tell you one example. Section 18, before that, I'll just read one paragraph, one aspect of section 18 and then go to that. Any of the following documents may be registered under the Act, namely instruments other than instruments of gift and wills, which purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, a value of less than 100 rupees in or immobile property. So 100 rupees and below immobile property, as mentioned in section 17(1)(b), is optionally registrable. And it is mentioned that will is also an optionally registrable document. You will find it in 18E, wills. So there are other documents also mentioned. I'm not taking you to that. So the point is, section 17 speaks about compulsory registrable documents. 18 deals with registration which are optional. For example, if you create a lease for 11 months, it is not the mandatory requirement of law to register the document. If it is exceeding 1 year, it requires registration. Then, and I was just trying to explain, suppose an equitable mortgage is created by deposit of title deeds, and a memorandum is drawn up. There are a lot of decisions, I don't have the citations right now, but there are a lot of decisions which say that if the memorandum of deposit of title deeds is contemporaneous to the transaction, and if the value secured in the mortgage is more than 100 rupees, it is compulsory registrable because it creates, limits, extinguishes rights. So it falls under 17(1)(b). But if the memorandum of title deed evidences a previous transaction, for example, suppose an equitable mortgage is created 1 hour before, and a memorandum is drawn up saying that at 1 o'clock, the title deeds were deposited with an intention to create a mortgage in a notified area. So an equitable mortgage has been created in that context. And this document, memorandum, is only evidencing a previous transaction, which is not compulsory registrable because that is only an evidence of a foregone transaction. I'll explain this aspect when I deal with section 49 more elaborately. So this, you have to keep in mind these principles when we try to understand the scope of section 49. And straight away going to section 49, I shall just read that section for mutual benefit. Effect of non-registration of documents required to be registered. No document required by section 17 or by any provision of the TP Act 1882, that is 123, where gift has to be registered irrespective of the value. To be registered shall affect any immobile property comprised therein. So the law clearly says any document which is compulsorily required to be registered under section 17 or any other law, if it is not registered, it shall not affect any immobile property comprised therein. So it is of no consequence. There is no transaction happening by virtue of that document. If such a transaction is honest. Then B, confer any power to adopt, that is relating to deed of adoption. Then C, received as evidence of any transaction affecting such property or conferring such power. Now, I'll explain this expression in this, received as evidence of any transaction affecting such property, because you have to keep in mind the provisions in sections 91 and 92 of the Indian Evidence Act, the earlier act, which says that how to what extent contents of a document can be proved. So the theory that a document, when it is produced in evidence in a proper court, tendered in evidence in a properly legally correct manner, then if that document is received in evidence by the court, then that document itself proves the transaction. For example, if there is in a suit for injunction, plaintiff says that I have purchased the property from a third party, and this property, this is my title deed, I am in possession of this property, so I am entitled to get injunction against the defendant who is trying to trespass upon my property. If that is the case, assume for a moment, and he produces the sale deed in court, it's a registered sale deed. It is produced in court and it is marked received in evidence. So you need not, going by the principles in CPC, you need not prove the contents of the document, because the production of that original registered document itself is a proof of the transaction. So that is the substantive purpose for which this document was executed, and it serves the purpose, the purpose of creation of the document. So that is why the section 49C says to be received as evidence of any transaction. So when a document relating to a transaction which is legally, which is conforming to all legal standards, can be received as evidence of the transaction, which means that no separate proof is required, but produce the document, prove it in the proper manner. So the transaction is automatically proved. That is the significance of as evidence of any transaction. But there is a distinction between to be received in evidence. In evidence, the Privy Council, there are some old decisions which say that received in evidence means there is no guarantee for the correctness of the transaction. You have to adduce another evidence to establish it. So receiving in evidence is different from receiving as evidence. Once it is received as evidence, the transaction is automatically proved by this document. So that is the essence of that this clause. To be received as evidence of any transaction affecting such property or conferring such power. So when a document which is to be registered compulsorily under section 17, when it is not registered in accordance with law, the document shall not be received as evidence of any transaction which is purported to be created by that document affecting the immobile property. So such a document cannot be looked into if it is not properly, if it is not registered according to the provisions of this Act. Then it further says, provided that an unregistered document affecting immobile property and required by this Act or the Transfer of Property Act 1882 to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act 1877, that is the old Act, correspondingly 63 Act, or as evidence of any collateral transaction not required to be effected by registered instrument. So in the proviso, there are two aspects dealt with. One is relating to the suit for specific performance. The other is relating to collateral purpose. So these two expressions will have to be considered separately, and which is of some significance. Now, you are aware that the TP Act has been amended, Section 53A has been amended, saying that unless a document is, unless an agreement for sale or agreement to assign or contract for sale, whatever it is, unless it is not registered, it cannot be relied upon as a document for part performance. So that is the effect of that amendment. Consequently, there is a Kerala amendment. Then there are some state amendments, because I am familiar with Kerala amendment. I am telling you there are other state amendments also, making it mandatory under section. It is brought under section 17 to make it mandatory that this document has to be registered. But the Central Act, without this amendment, says that a contract, an agreement to assign land or a contract for sale of immobile property, even if it is unregistered, it may not be admissible for other purposes, but in a suit for specific performance, there is no bar in producing that document to prove the existence of the contract relating to sale of immobile property. That is specifically provided under the provision in the proviso. Provided that an unregistered document affecting immobile property and required by this Act or the Transfer of Property Act to be registered may be received as evidence of a contract. So it is as evidence of a contract, not in evidence of a contract. So when that unregistered agreement is produced to prove the existence of the contract between A and B to sell immobile property belonging to one of them, then this document can be received as evidence of the contract. And then come next aspect, or as evidence of any collateral transaction not required to be affected by registered instruments. So then Then the expression, what is collateral purpose? When a document is executed, normally it is executed with the intention of creating, limiting, extinguishing, or etc., as provided in section 17, rights in immobile property. So, if that is the main purpose, in the legal sense, we may call it the substantive purpose. A document is executed for achieving a substantive purpose of either selling the property or mortgaging the property or gifting the property or releasing the property, whatever it is. There is a substantive purpose to be achieved. If that substantive purpose fails for want of registration, then it cannot be received as evidence of any transaction as provided in section 49C. And section 49A says it will not affect immobile property. So then what is the purpose of that document? It is actually, you may think that it is only a base paper. No, but it can be used or it can serve another purpose of proving collateral transaction. Then what is collateral transaction? In simple words, I can explain collateral transaction is anything other than the substantive purpose. For example, if a sale deed is registered, declaring that A had sold his property to B for a certain sum and he has received the consideration, but it is more than 100 rupees, the document is not registered, so it cannot be received as evidence of the sale going by section 49A. Sorry, 49C. And it will not affect the immobile property of the seller. But then, in a particular case, suppose there is a dispute, how the purchaser described in the unregistered document, how he came into possession, if that is the question, he can produce this document to prove his possession. He may not get title, that's a different issue. But then if he is actually put in possession, if we want to protect his possession, either in a suit under section 6 of this Present Relief Act or in a suit for injunction, he says that I am in lawful possession, I have been in possession, I have been put in possession by the seller, and I am holding the property in right, but his title cannot be recognized, but his possession can be explained by producing this document. So that is a collateral purpose. So the main purpose could not be achieved by this document because it is not legally registered under section 17. So that purpose will not be served by this document, but a collateral purpose for which may be a limited purpose for which it can be used in this manner. Same is the case with lease. Suppose a lease for more than 1 year has been created. It should be created only by a registered document. Suppose somebody says that I am a lessee under the owner of the property, and the other man disputes. No, he is not the lessee, he is a ranked trespasser, if that is his contention. Then the so-called lessee, if there is an unregistered document evidencing the lease, and it is beyond 1 year, which cannot be used as a lease deed because it cannot be received as evidence of a transaction of lease, but then he can use it for the collateral purpose of explaining his possession as a lessee. Suppose this document is produced in a dispute, before the court in a dispute, and he shows that he has been paying rent. So this will create an impression in the mind of the court that yes, there is a lease. Maybe it may not go beyond 1 year because it is unregistered. But then there is a monthly tenancy between these two persons, which can be inferred from this unregistered document. That purpose is called collateral purpose. So, section 49, the sum and substance of section 49 is that the bar under section 49 is absolute, and a document which is to be registered under section 17, if not registered, it cannot affect the immobile property comprised therein. There cannot be a doubt. Second thing regarding adoption, which rarely comes nowadays, deed of adoption, if not registered, it cannot act as a evidence of that transaction. Then, and such a document cannot be received by a court of law as evidence of any transaction which it purports to have created by executing that document, because without registration, it doesn't achieve that purpose. So it cannot be received as evidence of any transaction. That is why I told you as evidence and in evidence is different. Even if it is received and marked in evidence, it cannot be looked into, because admitting a document in evidence is only an administrative act by the court. It doesn't confer that document the status of a reliable document, or rather the probative value or the admissibility is a question to be decided in each and every case with reference to the law applicable to that document. The law applicable to an unregistered document which should have been registered is very clear that Section 49 creates an absolute bar. Then the two exceptions I'll say, which is provided in the proviso, is that a contract for sale of a movable property is not a compulsory registrable. Even if it is made a compulsory registrable document, it can be received as evidence of the contract, as evidence of the agreement for sale. And one principle to be borne in this context in mind is Section 54 of the TP Act, which says, 4 or 54 or 55, please look into that, which says that an agreement to assign will not confer title on the buyer, because it's only a contract. It has to be enforced. So it doesn't convey title. But there is one larger principle in courts of equity in England has adopted a principle that there is a concept called equitable title and legal title. There is an equitable title by execution of this document, and in equity, the seller is agreeing to the buyer that I will sell my property if you pay me the price. So that there is some sort of gentleman relationship has been established by this transaction. So there is an equitable title. Anyway, we are not concerned with the equitable title. I just mentioned that principle here. That has no place in Section 17 or 49. I'm just telling you. So Section 54 or 55 of the TP Act says that an agreement to assign will not confer title. So that agreement need not be compulsory registrable, reading with this proviso, for the reason that it can be received as evidence of a contract in a suit for specific performance. It is very clear that it cannot be received as evidence in probably in any other suit, because the section saves only suit for specific performance. Then the collateral purpose, I told you, any purpose other than the substantive purpose. I'll give you some decisions, and some Supreme Court decisions say these principles that my friend Vikas has sent a recent decision, which is mentioned in this live law, where the principle that I told you right now, that in a suit for specific performance, the agreement to assign need not be registered. It can be still relied on to see that there was a contract between seller and the buyer. Recent Supreme Court decision. Those who are interested, please you can search in live law, or free citations are available. Now, this is settled law. There is no change. Of course, there are one or two decisions the other way around. Anyway, now it has been dispelled. Now the doubt has been dispelled. It has been clarified. That is the earlier position also. You will find some off-the-track decisions, but that is not the correct law. Then collateral purpose, there are some decisions by Supreme Court. One minute, I'll give you one decision. I have read one decision here. Yes, collateral purpose. What is a collateral purpose? For the purpose of Section 49 of the Registration Act has been explained. A foreign purpose not subordinate to purpose for which a document was executed is collateral purpose. So any purpose other than the purpose for which the document is executed is a collateral purpose. It should be a purpose other than that of creating, declaring, assigning, limiting, or extinguishing a right to immobile property. An unregistered lease deed, though inadmissible in evidence, can be looked into to understand the nature of possession, which is a collateral purpose. So that is it. Suppose the lessee says, I am a lessee under him, which should have been registered, but not registered by the lessor. And lessee says, I am a lessee. The other man says he is a trespasser. So to explain the nature of possession, the lessee can rely on this document. You may please refer to so many decisions there. Sorry, that's not Supreme Court decision. Sorry, It's not a Supreme Court decision. Anyway, this is the settled principle. There cannot be doubt on that. Unregistered deed. You may refer to 2012 8 SCC 516. Ahmad Sahib versus Saeed Ismail. Then 1991 1 SCC 715. There are so many decisions on this point explaining the collateral purpose. Then, so often the mistake committed by the trial courts and at the trial stage is that whether a particular document can be received as evidence has to be decided then and there. If you are not able to decide that aspect at the time of trial, there may be complications when you go to the appellate stage or in the second appeal stage. You will find it difficult because a document which should have been admitted cannot be rejected, and a document which could not have been admitted cannot be accepted also. So this principle under Section 49 has to be carefully examined by the lawyer fraternity as well as by the judicial officers to understand that Section 17 is a very, very clear and rigid provision which says that certain documents have to be mandatorily registered. Then Section 18 gives you the option whether to register or to register. So Section 18 has no direct bearing on Section 49. Section 49 deals with Section 17 only, which says that such and such documents are to be registered mandatorily. And if not registered, the Section 49 says that it does not achieve the purpose, it cannot affect the immobile property involved in the document. If it is intended to go for an adoption, it cannot be relied on for adoption. And even it cannot be received as evidence of the intended transaction because it can only be used for a collateral purpose, which is covered by the proviso. And the only exception in the case of an unregistered agreement for sale is that it can be used in a suit for special performance only for proving that there is a contract existing between the seller and the buyer. That is the only principle, that is the only purpose for which a contract can be used. So these are the broad principles. There are a lot of decisions on this point. I accept that a recent decision as pointed out by my friend Mr. Vikas. You will find other decisions by the Supreme Court and various high courts have pronouncements on that. And this particular decision I followed in one of my Kerala cases as a judge when I was sitting there. This received as evidence and received in evidence are two different concepts, which received as evidence means once you produce the document, that itself is proof of the transaction. But received in evidence means there are so many things you receive in evidence. The probative value will have to be decided with reference to the fact situation in each case. So the expression as evidence is very important. Please keep it in your mind. So these are the broad principles. Mr. Vikasji, if there is any question coming up, probably I can explain and wind up. Because?
No, sir. There is no question. I was just checking the judgment which I had shared.
Any chat questions I have not seen?
No, sir. So you have already explained with your vast experience as a lawyer, then as a judge, and then again as a lawyer. I'm quite sure that people will understand. And tomorrow we will take another interesting aspect, that what is the scope of emergency, etc. What are the types of emergency? Mr. Amit Pai, an advocate from Supreme Court of India. Do join us tomorrow at 6 p.m. And thank you, sir, for sharing your knowledge.
Thank you. Thank you. Thank you, sir.